Our next speaker is Professor KOVAČEK STANIĆ from the Novi University. She will speak about the legal concept of family protection in the Serbian legal system. Please take the floor, Professor.
Thank you very much, Professor Vekas, Professor Silaji, ladies and gentlemen, and all my colleagues in family law. First, I would like to thank the Ferenc Model Institute of Comparative Law for the opportunity to participate in this project about family and family law. But this is on personal ground. What is more important is the research itself, as well as establishing the Central European Professors Network, which enable professors from Central Europe to work closely on issues about family and family law. As you can see, in writing my presentation, I questioned my original title and a principle of promotion of the family to the principle of protection of the family. Why is that? Family protection as a principle includes state measures and legal norms with the aim to protect family. I think it could be said that family protection principle derives from a paternalistic approach to the family. Family promotion as a principle includes state measures and legal norms with the aim to strengthen family. I think it could be said family promotion derives from family autonomy as a contemporary legal concept. So my question is, can we talk about family protection and legal concept of family promotion? So I will try to answer this question. And to start with Lev Tolstoy from Anna Karenina, we all know that he said in this very famous novel, all happy families are alike. Each unhappy family is unhappy in its own way. But my question is, are all happy families alike and is it true for the 21st century? Do we have a lot of variation of families, happy families in 21st century? So I will start, it will be a kind of overview of norms in Serbian family law which protect and promote family. I will start with family autonomy or self-determination principle, which is one of the most important principles in contemporary family law. I can say that this is also very important to mention protection from domestic violence, mediation, habitatio, and the interest of the child to have two parents. I will first talk about the self-determination principle, which includes joint exercise of the parental right, in my opinion, resolving parental conflicts, and legal position of the child. The joint exercise of parental right exists in Serbia from Family Act 205. A joint exercise of parental rights should be granted only if the parents agree to this type of a parent-child relationship. Of course, I'm speaking about the joint exercise of parental rights after divorce or separation. They must make an agreement which the divorce court shall accept if it deems this agreement to be in the best interest of a child. The agreement becomes an integral part of the court decision. After separation or divorce, the parents may make an agreement on the joint exercise of the parental right as well. There is controversy as to whether the Family Act should introduce the possibility of alternating residence of the child dividing his or her residence between the parents. There are opinions, mostly from psychologists, psychiatrists, that dividing residence between parents is contrary to a child's need for stability. But in other way, this promotes family and family of mother and father. In Serbia law, there is a proposal that parents should stipulate the domicile of their children in the agreement. It seems that this solution does not exclude the possibility of a child living with both parents in this way, and in this way we can talk about binocular family because the child will have two families on the same level of importance, the family of mother and the family of the father. But this solution is really complicated and also very expensive because it suggested that family has exactly three homes, one of the mother, one of the father, and sometimes this solution, which we call the bird nest, which means that we have three homes. One is the family home originally, the other one is family home of father, and third is the family home of mother. So mother and father are coming to the originally family home and take care of their children. So this is bird nest, and in this way, yes, and in this way, we can resolve stability for the children because they stay in their original home, and mothers and fathers are changing in months or weeks. But this maybe this would be something in future, maybe better solution than we have today. But for now, this is the exception, I must say. And in Serbia, I don't know about this solution. Yes, far away. But I heard about this in France. The other issue is resolving parental conflicts. This is a very important issue in family law. What is the way to resolve conflicts between parents? The competent authority in Serbia and in most countries for this is court. First, court should try to conciliate the parents through family mediation conducted by competent authorities. Secondly, the court should have the option to authorize one of the parents to act alone with regard to one or more specific decisions. And thirdly, court should make decision by itself on some issues. And the third issue in self-determination of the family is legal position of the child. Influenced by United Nations Convention of the Rights of the Child of 1989 and other relevant international documents, Family Act Serbian introduced the different concepts of rights and duties of parents and children. Rights of the child are stated in a separate chapter and have been broadened in comparison to previous acts. Chapter 2 on the child in parental care contains a section on the rights of the child in 9 articles, but other parts of the Family Act contains rights of the child as well, with the opportunity, which is very important, to exercise these rights independently. New approaches to the rights of the child mean establishing a wide range of such rights. Special attention is focused on the right of the child to form and express his or her opinion in all issues that concern him and her, in all procedures on their rights, having in mind the age and maturity of the child. What seems most important is the promotion of the possibility of children to exercise the rights on their own and not by parents or guardians, as it has to be as it has been in the previous periods. The third issue is protection from domestic violence. In family law, members of the family, in terms of domestic violence, is very broad in order to protect as many victims as possible. These are spouses or former spouses, children, parents, and other blood relatives, in-law or adoptive relatives, and persons related by foster care. Persons who live or have lived in the same family household, cohabitees or former cohabitees, and also persons who have been or still are in a mutual emotional or sexual relation, or have a common child, or the child is to be born, although they have never lived in the same household. So the aim is to protect as many persons as possible, and this is what Family Act did. The second issue is mediation procedure. This term, mediation procedure, includes procedure for attempts at reconciliation and procedures for settlement. Mediation will ordinarily be a part of matrimonial dispute procedure and is not in the procedure for divorce by mutual agreement. However, it will not be carried out if the spouses do not agree to mediation, if one of the spouses is incapable of reasoning, or if the residence of one of the spouses is unknown. The reconciliation was conducted as a part of divorce in the Serbian legal history as well, based on the Orthodox rules of marriage of the Serbian Orthodox Church. And I think this is nice to mention because it is something that we had in history, but it's also very important today. The aim of reconciliation, according to the Orthodox rules, is reconciliation of the spouses and abandoning the idea of divorce. And this was in the following way. The priest tries to conduct reconciliation of the divided spouses fatherly and kindly as his priest's duty. While conducting the service, the priest will take into consideration only the sanctity and importance of marriage and will not take care of any other reasons. He will especially avoid all the issues that can intensify the conflict or could lead to an impression that he is taking the side of the party who is rejecting reconciliation. The attempt of reconciliation shall be conducted in such a way so that it clearly leads to a conclusion that the Church supports forgiveness between the spouses and expects reconciliation of the spouses for higher Christian goals. If children are born in marriage, the priest would ask for reconciliation for the children's sake, who would suffer inconstantly. So I think this article, this paragraph, which was introduced in Orthodox Church before Second World War, could be in some way good, or in this first process of mediation, it could be applicable also right now. Another issue, I think it's very important for the promotion and protection of family is in Serbian law habitatio. This is the institution which is introduced in Family Act 205. The child and the parent exercising parental rights have the right to residence in the apartment owned by the child's other parent. If the child and the parent exercising parental rights do not have property rights to an unoccupied apartment and until the child acquires maturity. This is very important to protect family after divorce or separation, and it enables family to stay in a family home or family house, even if the family house is in the property of the other parent, probably, and mostly it would be father. Another issue which I would like to talk about is the interest of the child to have two parents. is there an interest of the child to have two parents or not? And is this interest in promotion or in protection of the family? I divided this issue in several items, and there are, in my opinion, three interests to have two parents: psychological, developmental need, then material interest, which would be maintenance and inheritance, and right to know biological origin. On the other hand, of course, exists reproductive right of the single woman or the single man. Also, we have in practice birth of the child of a mother who is not married, which means birth of a child born out of wedlock. There are some situations that we can talk about the interest of the child to have two parents, if that exists or not, and is there any possibility to take account of that interest, even if we have single woman in reproductive process, or even if we have a woman who is not married and a child born out of wedlock. If there is a situation of a child born out of wedlock, there is the obligation of the registrar to counsel the mother and also the father. So the registrar is under the obligation to instruct mother on her right to name the man she considers to be the child's father. If the man the mother named as the child's father fails to give any statement within 30 days or state that he is not the child's father, the registrar is under the obligation to instruct the mother on her right to establish paternity by a court procedure on the court decision. So I think this article, this provision, promotes in somehow the interest of the child to have two parents. Forms of acknowledging paternity also enable father of the child born out of wedlock to become a father legally, and we have in Serbia very different forms, which are the form in register, the guardianship authority, a court, and on notary public. So this wide range of acknowledgement, I think it also promotes the interest of the child to have two parents. And also the issue in adoption. In Family Act, there are provisions that spouses or cohabitees may adopt together. Exceptionally, the ministry responsible for family protection may grant adoption to a person who lives alone if there are particularly justified reasons for doing so. So this is only an exception to allow the person who without a partner or spouse to be adoptive parent to a child. And this is also one of the articles which promotes, I think, the interest of the child to have two parents. If we think about artificial reproductive technologies and the right of a woman without partner to have the opportunity to have this one of the artificial reproductive technologies procedures, that would be heterologous procedure with the semen of the donor. So in Serbia, this opportunity is only exceptional option in Serbia. But comparatively speaking, I would like to mention a solution of the Human Fertilization and Embryology Act of United Kingdom, which introduced supportive parenting. And this is how they explain that. Where the child will have no legal father, the center should assess the prospective's mother's ability to meet the child's needs and the ability of other persons within the family or social circle willing to share responsibility for these needs. I think that is also a very good, I think, way to think about the interests of the child, to have two parents, or maybe here he will not have two parents, but someone who will be in a function of parent as persons within the family or social circle of the mother who is willing to share responsibility for a child's needs. And in my next part of my presentation, I would like to mention other acts besides Family Act which protect or promote family. This is a law on biomedically assisted fertilization, law on labor, law on financial support for family with children, and law on retirement and disability insurance. Law on medically assisted fertilization introduces different procedures or technologies available to the man and woman to help them to become parents. In Serbia, not including surrogate motherhood. From 2020, the procedure for the stimulation are free of charge, limitless, and 3 embryo transfers for the woman until reaches 43 years of age are free of charge as well. And for the second child, 2 procedures for the stimulation are free of charge and 1 of embryo transfer. I think that this is something that is just in promotion of the family. Law on labor, we can talk about maternity leave and the leave for the child care. Maternity leave lasts for 3 months after the child was born. Leave for the child care for additional 9 months. Maternity leave is the leave for the mothers, mostly. The father can take it only if the mother is not able to care for the child. But leave for the child care is available for mothers and fathers depending on the parents' agreement. It is possible also to share leave between parents. Also, law on labor stimulates birth of third and fourth child. The maternity leave and the leave for the child care last 2 years for the third and fourth child, and on the other side, for the first and second child, the maternity leave and the maternity for the child care lasts for 1 year. Then there is law on financial support for family with children, which introduces different allowances: parental allowance, child allowance. The parental allowance is a sum which every parent gets for a financial help when the child was born, and it is progressive, depends on the number of children, but not on the social status of children. So these sums will receive every family, not just socially poor families. So this is what are the amounts. For the first child, this is one lump sum. It's 100,000 dinars. For the second child, it's the sum, which is 24 monthly payments. For the third child, in 120 monthly payments, and for the fourth child, in divided in 120 monthly payments. So these payments, I think, are not so bad. Maybe not able to provide the family, but I think the progressiveness of the allowances is very good for promotion the family. And I would like to mention something, an act which was introduced in Vojvodina. That was the program for the demographic development of the Vojvodina with the measures of its implementation. And I would like to mention most important measure, that was the financial compensation for the third child. It was like this: to the mother, in the amount of average monthly wage in the province until the child has reached the age of 19. So an extra payment as average monthly payment until the child reaches 19. Unfortunately, I think this measure seems important, and maybe it could be stimulation for the families to have a third child, but unfortunately this measure has not been applied due to the lack of funds, unfortunately. Also, law on retirement and disability insurance favors the birth of a third child, stipulating that the insured seniority here, the seniority of a woman who gave birth to the child, is to acquire during the 2-year maternity leave a special type of seniority. So, in my conclusion, I'm going back to my question. Can we talk about legal concept of family protection and legal concept of family promotion? The answer might be legal concept of family protection and legal concept of family promotion. Family promotion is, of course, necessary in some situations, for instance, domestic violence. But family promotion should prevail in contemporary family law, as modern family has autonomy, but in order for family to be strong, needs help of the state. Thank you for your attention.